Good afternoon, ladies and gentlemen, national and international colleagues, for your participation in this press conference after the completion of the closing statements in case 002/01. My name is Rom, Chief of the Public Affairs Section, and La Son is the Legal Communication Officer. And Chung Tieu Chia Ling, the National Co-Prosecutor, Mr. Nicholas Kum Chuong, the International Co-Prosecutor, as well as Mr. Hood, the Deputy Co-Prosecutor, and Mr. William Smith, the Deputy Co-Prosecutor. This session for the prosecution is 20 minutes, and for the two subsequent teams, the time allocation is also 20 minutes. First, there will be a speech for 2 to 3 minutes by the co-prosecutors, and then the question-answer session follows. And I'd like to invite Madame Chia Ling to make a brief statement. Jillian, thank you. Good afternoon, and I'd like to welcome national and international journalists who are here today. As you all know, today is the last day of the hearing in case 002/01. This is a historical moment that we have been waiting for more than 38 years. It's a long time that we have waited for the moment, and although there is no judgment, this is a main success for everyone, and we look forward to the judgment by the trial chamber. And of course, we believe that justice for the victims will be shown, and we have achieved our success so far, and we hope to look forward to the judgment. And as the time is limited, I'd like to give the floor to my international colleague, and if you have any question for us, please do so after the presentation.
Thank you. I echo my colleague's remarks that this is a historic time on a historic case. Every day, countries and many events are going on in the world that distract our attention. But these days are very important because they will be recorded in history, and people will look back on what was said during these last 10 days of oral hearings for many, many years. Many people in Cambodia and others around the world not yet born will look and read the history of what happened in the events of democratic Kampuchea from the outcome of this trial and from the arguments. I have been in the international tribunals for the past 13 years, and I have never seen a case where the oral arguments went on in such depth. We had 10 days, full days of oral arguments. In most cases, it's most typically 3. And these oral arguments, I thought, on both sides were of very high quality. I compliment the defense attorneys. The defense teams in this case, the court made sure the defendants were defended by experienced and well-qualified lawyers who fought very hard for their clients. But I also compliment the prosecution team that did the case. I think they did an outstanding job. And in our oral submissions, I believe we showed why it was proven, beyond any reasonable doubt, legally, under international law, that the crimes charged were committed. So these days were very important, including today, and the opportunity to hear the final words of the accused persons. And I appreciate all the work that everyone has put into it.
Okay, thank you for those introductory remarks. We will now open the floor for questions from the journalists. Because we have simultaneous interpretation between 3 languages, I kindly ask you to wait to ask your question until you have a portable microphone. And please identify yourself with name and which news outlet you are representing. And we can start with Cambodia Daily.
Hello, can you hear me? My name's Lauren Crothers. I'm a reporter for the Cambodia Daily. I'm interested to know your thoughts on the closing remarks from Nuon Chea and Khieu Samphan, whether you think there were any surprises there, or just your thoughts in general about their final arguments for their cases.
I would just say that we listened with great interest. I would not say we were surprised. Khieu Samphan basically decided not to address the evidence against him, and Nuon Chea added his excuses for why he believed, because that they were defending against Vietnam, that killings of Cambodians would take place across the country. Obviously, that's my interpretation of his remarks. But we also were very interested in the fact that Nuon Chea placed Khieu Samphan within the decision to evacuate Phnom Penh by saying all members of the Central Committee took part in that decision. So it's always interesting to hear the remarks of accused persons. Obviously, it's much better when you have a chance to cross-examine and ask questions about them. But certainly, we listened with great interest today.
Hello, my name is Chanthol from Reuters. So you said that these days are important for Cambodians. But what you think how people are amazed by the time that it takes to render justice? It takes 205 days to just hearings, Just want to hear from you. Thank you.
Yes, that has been a problem recognized in international justice and other tribunals also. And I agree 100% that it's something that we have to work on. It's very important that justice be done as efficiently as possible. And it's not good that we're having justice 38 years after the events. It would be much better to have it sooner. But we don't have a choice now to have it sooner. The choice now is to have it now or never. And in my view, it's absolutely clear which is the better choice. We have an opportunity now that is fast disappearing, and we have to take advantage of it.
Hello.
Good afternoon, I'm Sok Saray. I'm from Southeast Asia TV. Over the last 10 days of this closing statement, you said earlier that there was a high quality of arguments from both sides. What do you mean by high quality arguments? And do you think that the defense team, particularly Mr. Nuon Chea himself, admitted whether or not he was responsible during that regime? Prosecutor Chiliang. Well, I would like to respond to this question because I understand the question in Khmer. Well, I consider this hearing as one of the historic and important moment. Why? Because the chamber has already heard over 212 days thus far, and all parties were granted the opportunity to present their arguments, to present their parts of the story. Why do I consider the trial, the presentation and arguments by parties as high-quality arguments? Because they relied on evidence, they relied on testimony. Even though Khieu Samphan did refuse to speak in court, but he must have already known, because in the court we presented a lot of documents as the evidence. He has been copied and sent the telegram of up to 60+% of all the documents during the entire period of the democratic Cambodia. So we have gathered information, evidence, for example, the evidence from the interview of the accused themselves and other surviving witnesses as well. So now we are trying to use what he has interviewed with reporters and journalists alike, and but now of all a sudden he said that he did not know anything what had happened during the democratic Cambodia. He was not responsible for anything that happened during this period. So that was not convincing enough, because the evidence was abundantly clear that he was responsible for that. And Mr. Nguyen Chir was the same. He said that he was powerless and he could not do anything. I don't find that it is convincing. I don't think that the chamber will be convinced by this because we have had abundant documents, including telegrams, as well as documents in the foreign depositories, as well as documents available in Cambodia, and the surviving witnesses as well. Even though it happened, the crimes took place some 38 years ago, but there has been a lot of evidentiary document left to prove their responsibility. And in addition, we understand that we have been facing with daunting challenges concerning the old age of witnesses, and there are some other issues concerning the evidence available for that. And some of the witnesses have been waiting for too long. We understand the victims have been waiting for too long for justice. But at least by engaging them in the process, it is one way or another console them, and I hope that that will more or less appease them to a certain extent. And I know that the accused will not admit it in court, but it will not depend on them. It will depend on the chamber, the judges, who will decide at the end of the day whether or not they are found guilty. Thank you.
Okay, before we continue, just to utilize the minutes we have left of this session, can I just get a show of hands for how many more questions we can expect? 1, 2, 3, 4. Okay, so I suggest that we do as follows. We do the 4 questions we have outstanding all at once, and then we just take the answers to all 4 of them to utilize the time we have left. So then we start with Al Jazeera.
Okay, I'm Kate from Al Jazeera. I wanted to follow up. You mentioned that it's a fast disappearing window of opportunity that you have. Obviously, the case 2 has been split into mini trials. There's case 3, possibly case 4 as well. How is the court going to proceed from here?
Next one, Lauren, your second one. Okay. Okay.
I am Soksaray. I have one last question. Now I would like to turn to the issue of financial support to this court. For 2013, it has been secured for both sides, but how about from 2014 and 2015? Do you have any concern for the budget shortcoming? Can you please enlighten us on this issue?
Other outstanding questions?
No more questions?
Okay, so then we can leave these 2 questions to the co-prosecutors, please.
Prosecutor Chiliang, I would like to respond to this question. I have heard 2 questions. The first one concerning the next steps, the next cases. As you heard, the President announced at the end of the hearing, after the closing of case 002/01, then they will move on to case 002/02. There are actually 3 segments of case 002/002. The chamber has now dealt with the alleged crimes against humanity, and the trial chamber announced toward the end of today's hearing that they will organize a trial management meeting sometime very soon in order to outline the next action to be proceed. I don't know. It's all up to the trial chamber to decide. Now, on the issue of budget, that is an issue that is beyond our knowledge of the prosecution. It is the task of the Office of Administration. But to our knowledge for the national side, for 2013, we have secured funding toward the end of 2013. But as for 2014 and 15, I have no idea whether or not we can secure funding. But I cannot say anything about it because it is not within our responsibility. The Office of Administration may enlighten you on this issue. I know that it is a challenging and pertinent issue as well, because we have a concern, because we know that the accused are now at their advancing age now, and there is a real threat of concern for the health issue of the accused. As you know, Nguyen Chia remained in the holding cell for almost the entire proceeding over the last couple of months due to his health reason. But he followed the proceeding remotely, but I know that their health are now getting worse each day because of their old age. I hope that they are going to survive until we can find justice for the victims. We have additional evidence to be put before the chamber for the chamber's consideration.
If I could briefly respond, I believe the two questions are related in the sense that the donors, I believe, will be willing to fund this court when we can show them that we are moving forward towards concrete results in an efficient manner. So that's what we hope to work out with the trial chamber in this trial management meeting, how we can move forward in case 2 efficiently and achieve results so that the donors and the people get what they are paying for, what they want, what they seek. And just to go briefly back to your other question about the accused and what I meant by the quality, I think it's interesting what they say, even if I reject it. Nguyen Chia, for example, talked about his knowledge, his detailed knowledge of crimes by the Lon Nol regime and his detailed knowledge of crimes after 1979, but claims no knowledge of crimes going on in the very regime in which he was second in command. So we found that very, very important evidence. And also, ladies and gentlemen, I was impressed by the clear intelligence of the accused. The fact that Nguyen Chia said he's been following carefully all of the evidence. This shows again that this is a very important proceeding because the accused are fully engaged. They're fully mentally capable of cooperating with their defense teams. So that is why I believe this trial will reach a quality result where the ultimate judgment of the court will lift the veil on some of the lies of democratic Kampuchea and lift the veil on the actual criminal enterprise of that regime.
Thank you. If I can just add to the question from the woman from Al Jazeera, as you know, with this trial, the prosecution disagreed with the trial chamber that it should be split up into these smaller trials. However, the fact that it has, there's some very important charges still to be heard. As you know, in this case, we were dealing with the beginning of the regime, the implementation of the enemy policy against Lon Nol officers and new people from the cities. It was just at the beginning, and the regime got worse and worse. And we particularly want to make sure that the prosecution of these accused for genocide against the Cham, genocide against the Vietnamese, and for all of the security centres that were set up around the country to kill enemies on a massive, massive scale. Extrajudicial killings which are almost unheard of in the 20th century. So as much as we would have preferred that we had some of those charges in this case, we think it's extremely important that we have this next trial. And as Nick and Liang has said, we understand the pressure as a prosecution office. We have to move fast. We have to move very fast. We have to be professional. We are not backpackers in purple robes. We're serious professionals that have been around for a long time. And we understand the need for expeditious justice, and we'll move as fast as we can, and we'll push the chamber as fast as we can to make sure that happens. We've done a lot of work in preparation, so this next trial should get off the ground far more quickly than the last one, and it should be done as short and concise as possible. But these are extremely important charges. Only a third of the story has been told, and the other story needs to be told and told quickly.
Okay, since there was a question of a bit more general nature beyond the prosecution, which is about the financial future of the court, I will take off my MC hat for a moment and put on my ECCC spokesperson hat and provide you some information about the budget process. I understand that there is foreseeable funding for both the national and the international side for the remainder of this year. Then, of course, the big question is 2014 and 2015, which is the next budget cycle. What I can say that the budget for these 2 years is currently being finalized, and it will be presented to the donors in New York in about 2 weeks' time in a pledging conference in New York. Of course, we are working very closely with all the stakeholders of the court to ensure that we have the sustained necessary, not only political support, but also financial support. And we remain hopeful that all those who have a stake in this court will come forward to secure that the funding requirements for the next 2 years will be met after we have presented the budget.
Thank you, Lars. Thank you, National Prosecutor, Mr. Nicholas Kunchong, and the Deputy Prosecutor, National and International. The time is now up for this press conference for the prosecution. I thank you very much, both national and international prosecutors, for your company. And now I would like to proceed to the next theme of the defense. I thank you very much, co-prosecutors.
Okay, if there is any general ECCC questions while we're waiting, feel free to table them now. Okay, Stephanie.
Microphone.
Okay. I'll repeat the question because there was no microphone. The question is basically whether we have any idea when the Supreme Court chamber will issue its severance decision, right? Its recent decision. Well, the only thing I can say about the Supreme Court Chamber's severance decision is that it's in the process of translation and being finalized, but we don't have a date when it will be issued. We have no indications that it is holding up any other decisions. I can't speculate when the decision from the Supreme Court Chamber on the severance will be issued. As I said, it's being worked at the moment to finalize it. Yeah, together, all together.
Please.
You don't need to speak consolidated, but it's just practical that you sit together.
Up to you.
Yeah, it's 3 languages. So.
Would like to welcome to the defense team. We will begin with the defense team for Mr. Nguyen Chia and defense team for Mr. Khieu Samphan. Now, I would like to inform counsels that we have 20 minutes for this press conference, like the prosecutors as well. And before we grant the floor for the question to the 2 defense team, I would like to invite both national and international counsel of the co-accused, Mr. Nguyen Chia and Mr. Khieu Samphan, to make an opening statement, a very brief one, around 1 and 2 minutes or so, concerning your participation in this press conference, and then we will open the floor for the journalist to put question to you. So now I would like to invite the defense team for either Mr. Nguyen Chia or Mr. Khieu Samphan. Anyone can start first, please. Mr. Sunarun, would you like to start first? Mr. Sunarun is the National Defense Counsel for Mr. Nguyen Chia. I am Sunarun. I am the co-counsel for Mr. Nguyen Chia. I am honored to be part of this press conference following the conclusion of Case 002/01, which my client, Mr. Nguyen Chia, was part of this proceeding. And now it is a good opportunity to meet with the journalists. I actually do not have any specific things to share with the members of media, but if you have any specific question to my team or to myself in particular, I will be happy to answer the question. Moderator, Mr. Coupe, do you have anything to add to your national counsel? If you have nothing to add, then the counsel may, of course, take the floor. But if you have anything to add, please feel free to do so now.
No, actually, I have nothing to add. Everything that we wanted to say, we have said in the court proceedings. But we are very happy to answer any questions that you might have.
Thank you very much, counsel. Mr. Khieu Samphan, do you have anything as an opening statement before we open the floor for the members of media or Counsel Vakang or Counsel Antagise, if you like? Thank you. I am Khieu Samphan, and my co-counsel on Antagise and Mr. Vakang. They are both the French counsels. And I think that the journalists and members of media have been aware that so far we have been very firm with our stance that Mr. Khieu Samphan is not guilty of any crime as alleged. I know that the prosecutor have brought many charges against my client, but we believe that our client is not responsible for those crimes, and we have actually given our defense for our client.
Do you have anything to say, or we can move straight into the question and answer session? Yes, I have been given the opportunity to hear some of the responses given by the prosecutor during the 20 minutes allotted to them, and would like to base myself on what he said to underscore the difficulties that we faced during this trial. Unfortunately, it is not with a view to calling into question what has been done, particularly with regard to translation. As you know, when we speak in French, what we say is subsequently translated into English and Khmer and vice versa. And sometimes this can give rise to some controversial interpretations, such as the one that the prosecutor has just referred to a while ago, which is that Mr. Nguyen Chia allegedly said that Mr. Kyo Sampan attended the meeting during which the decision to evacuate Phnom Penh was taken. I would quite simply refer my colleagues to the transcripts in Khmer, because Mr. Nunchia spoke Khmer, and he stated that the persons who attended the Central Committee meeting were chiefs of zones. That again is one of the examples of the difficulties we've faced during the 2 years of this trial. The problem is that sometimes key statements of witnesses and accused have to be translated into several languages, and very often it is done simultaneously, which is not easy and can give rise to many errors and some kinds of assertions that may come through what we heard from the accusation, from the prosecution. That is an example. To conclude, let me remind everyone that during the closing arguments, we have very important statements made. It is a high point of the trial, and we continue to restate the case of the defense. There are objections, and they try to narrate the case of the client. That is what we've been trying to do. What is valid for the trial is that we've been able to highlight some of the aspects of the evidence presented in this trial which have not always been put forward, be it by the co-investigating judges or by the prosecution. And one may wonder what the defense is doing. That is precisely our role, to highlight what is on record, whether people want to see that or not. Precisely, the work of the defense has been done to the best of our ability under the difficult conditions we've been working in. We've had difficulties relating to language, problems relating to interpretation of what we say. Reading of transcripts is extremely important, and this is interpreted differently depending on the case of the party involved, because the truth, and we are always talking of bringing the truth to light, because the truth emerges from a confrontation between all the different cases. That is what I wanted to just highlight.
Thank you. Now I open the floor for question.
Questions to the defense teams? Okay, AP.
Hello, my name's Supeng from AP. The question to Kyo Sampon, defense lawyer. Just quickly would like to know from your point of view, why Kyo Sampon not make any statement, why Kyo Sampon not ask the tribunal to acquit. He do so because he know that he's not responsible, or he was not involved with the crime committed under the Khmer Rouge regime. Thank you.
Not only it's because of that, but he stated clearly that he hoped that the tribunal, in spite of everything, would render justice in light of what he had explained earlier. It is clear that he hopes and believes that under the conditions under which this trial has unfolded, he will be acquitted.
Crothers from the Cambodia Daily. I think this is probably a question that both teams could answer, but as you might have heard the prosecution say, they're quite willing to push forward with getting case 2/02 underway. They said they're quite keen to keep working at that. I'm just wondering what the defence stance is on that, and also I guess maybe you can explain to us the legal situation. If, for instance, when that case might start, would it start before the verdict, after verdict, during an appeal? What are the legal implications there?
We're actually quite keen on having case 2/2 starting. As you know, we made quite a strong argument to include genocide charges. Our client has always denied that genocide took place. I think this is one of the most important legal questions. So also S21 is going to be part of this second trial, and it is time that the evidence allegedly present is really coming under serious scrutiny. So in that respect, we welcome the start of the second trial. If that has to be done under the supervision of this panel, that is of course a very good question. There are a lot of difficulties, legal difficulties and obstacles if you have these same 5 judges dealing with all kinds of questions that are also going to be asked in the second trial. Our preference obviously would be that a second panel will be established as soon as possible, and that we go further with the second trial on the guidance of 5 new judges.
Oui, nous n'avons pas.
Yes, our position is not quite the same. In answer to your question, I wouldn't say that we are favorable to the subsequent trials. We are looking at the conditions under which this trial will be based. And as we consider different circumstances, we find that the conditions are not acceptable, quite simply, for the same reasons that we have raised during the past trial, that is the case 002/01. These reasons have to do with the scope of the trial. You have understood, if you followed the proceedings, that we are pleading that there are genuine difficulties on the manner in which the case was severed. And we have also asked questions whether the trial should have included aspects that should be covered in the second trial. So it appears that we have started adjudicating matters in the first case that should be in the second case. And this is not acceptable. It is not acceptable to start a trial without knowing what legal facts have to be examined. It is also possible to cross-examine a witness. If you do not know the definitive answers that have been given to this question in the first case, you cannot defend your client efficiently in the second case. It is logically impossible, even if you change the panel of judges. It is not only a question of the panel of judges. It is a question of logic. It is a legal question. It is unacceptable to open a second trial segment unless an answer has been given to the first question regarding the first case. Kyo Sampan did not appeal against the severance decision because it is in his interest that justice be rendered as quickly as possible. And today he finds himself in a situation in which he's being said, "Sir, we are going to use elements on which the first case wasn't based to sentence and try you." It's quite simplistic to say so. It is a loss of the points of reference. We lose our bearings as we want to rush into the second case. And without solving that problem, can we start the second case? It is quite simply unacceptable.
Kosapon allied to add that if you follow the proceedings, the trial chamber actually covered the entire case of 002, but later on, the trial chamber severed the case, and the severance should be based on the legal facts. However, in practice, for example, the prosecution raised the facts outside the scope of this first trial. So the question is, if all those facts are or have been discussed in this first segment of the trial, and whether there is any ultimate or final judgment to it, then that will be used as a basis. But it will be difficult to start another segment of the trial without having the first facts adjudicated properly in the first segment of the trial. And that is the issue. There has to be an ultimate reason first for the first segment of the trial, and there has to be a clear setting for what facts to be tried for the second segment. Sunarun. I also like to add to case 002. As for us, Nuon Chia's defense, we do not agree with the decision of the trial chamber regarding the severance of the case, and we actually lodged our appeal to the Supreme Court chamber, and that is our position.
More questions?
Hello.
Yeah.
J'ai une question pour Monsieur Copé.
I have a question for Mr. Copé. You explained during the closing arguments that there was some kind of political aspect of this trial. What would change if the panel of judges is changed?
That's a very good question. Probably nothing. No, I mean, that's a short answer. The longer answer would be that the underlying mechanisms would still be the same, obviously. Maybe the only thing that would really make a difference is a change of government, but that is something beyond my capacity.
Paul.
Just to be efficient with the time, are there more questions beyond this one?
My name is Charles Paul from Cambodian News. As stated by the prosecution, Nuon Chea raised the facts about his knowledge of the killing and the tragedy that took place before and after the Khmer Rouge regime. But he was not aware of the tragedy that took place during his regime. And my question is, if he was not aware of those facts, who would know about them? In his statement, he said decisions were made by Pol Pot, and as you are the defense counsel and that you need to find justice for him, what do you think about justice for the victims? Is it just a justice for one person or justice for all the victims? Sonaruna, I'm Nuon Chea's counsel and I'd like to respond to that question. All the charges by the prosecution and the civil parties against my client relied upon statement and testimony of individual witness or civil party. So it is not an overall allegation. Those allegations were sourced from each family or each victim or each individual. And of course the allegations, in my opinion, are not true. This is a massive trial, and it was based on the establishment by the government and the United Nations. And of course, politics do involve in this trial. And not only politics, economics, and every other aspect of the government. And for that reason, the trial saw not only focused on one individual, for example, on Nuon Chea or Khieu Samphan, but the entire government in all aspects of the regime shall be prosecuted if that is the case. Because these two individuals are not just members of the party, and the rest have not yet been brought for the prosecution. As Noji stated, why only the body of the crocodile is being prosecuted and not the head or the tail? Kung Samon, I'd like to briefly add to that. You compare the justice for one person and justice for the people. We are here talking the justice for an individual because the trial is concerning an individual. A person is being prosecuted here. So here we are not prosecuting the regime. Nuon Chea or Khieu Samphan is here in order to defend himself, not the regime. As the allegations raised by the prosecution are that against each of them. And if the prosecutions show evidence concerning responsibilities of each accused, then the accused has to defend himself and the justice not to be done for the accused. Justice needs to be done, to be seen to be done. And justice is not only for the victims, but justice is also for the accused. Moderator, the time is now running out, and if the councillors do not have anything else to add, I'd like to conclude the press conference for the defense teams now, because we now running into 21 minutes of the time, and I'd like to thank the defense teams for attending this press conference as requested by the Public Affairs section. And the next phase will be the press conference for the political lawyers for civil parties, and I thank you all.
We give floor to you, but you don't speak. No. But nobody asks you about the question. Okay.
Bon, peu importe. Hein. Non, c'est bon. Oui. Ông Nguyễn, ai còn quỳ. Voilà. Ok, bán. Ok. Au début, oui. Une petite introduction et après question-réponse. Ok. Prenez votre casque.
Help yourselves to a headset.
Moderator, thank you. Let me now begin the press conference with the lead co-lawyers for civil parties. And as you all know, the names and the positions of the civil party lawyers, as well as the lead co-lawyers. And as the previous press conference, first I'd like to invite the national and international lead co-lawyers for civil parties as well as the civil party councils to make brief statement, and then the floor will be given for the question and answer session. The entire time allocation is 20 minutes. And first I'd like to invite the national lead co-lawyer for civil party to make a brief 1-minute statement, and then I would give the floor to the international lead co-lawyer for civil party, Mr. Simon Ford. And later, if there is any statement to be made by the civil parties councils, the floor will be open to them. Back on. Good afternoon, ladies and gentlemen. Through the evidentiary hearing of 212 days, it clearly shows that the civil parties have high interest in the proceedings to find justice for them, and they actively participated in the proceedings, especially evidence, either oral or documentary, has been presented during the closing statements, and that shows the importance of the participation of the civil parties. This kind of international tribunal should allow the civil parties or the victims who actually witness the crimes directly should participate and have the right to find justice for themselves. And justice is not the only main thing that is important to them. Their direct participation in the proceedings is equally important. And that is important for them to understand the proceedings, to make them relieve and feel better, and that would lead to national reconciliation.
Thanks very much. I'd like to add a word or two. I completely share what my colleague Pekong has said. I'd like to say here at the close of this trial that we're particularly happy and satisfied. It was definitely a very significant historic and juridical moment, and at the outset, to be honest, we weren't quite so optimistic about our chances of reaching the end. So now I can say that we are happy. We are also pleased because, as Ong Pik said, the civil parties participated to a considerable degree. It was important for them. It was important for the case file. They brought a lot of evidence, and they were very important for the human dimension of this trial. As soon as you talk about crimes against humanity, then human beings are, of course, vital. From my standpoint, I think this was a fair trial, contrary to what the defense seems to be saying. We all had to conform to procedural and legal rules. It was the same thing for everybody. And I think it was necessary that the rules be respected for all parties, the civil parties included, and that was the case.
Christine
or Hong Kong Soon, do you have anything to add? Hong Kong Soon, thank you. And I'd like to thank the press representative for your attending this press conference. I am honored to be here to make our press conference. We are the civil party lawyers representing the civil parties and the victims. And it is important that we have reached this milestone. The trial chamber raised the issues of the victims of the Khmer Rouge regime and determined whether the accused are the ones who are the senior leaders and most responsible for the crimes committed during the Khmer Rouge regime. Those cruel acts have been supported by millions of victims and civil parties, although there are around 4,000 civil parties only in this case, but they are survivors from the regime, and they clearly stated what happened during the Khmer Rouge regime as a result of these leaders. Of course, they wanted to testify before this chamber, but because of the time limit, that only a few civil parties were allowed to testify. That is 32 civil parties. They are representative of all the civil parties and victims who died during the Khmer Rouge regime. So what has been denied by Nuon Chea and Khieu Samphan is their right, but for us, the civil parties, we are still of the firm view the truth prevails. Those who lived through the regime survived, and there are quite a lot of survivors from the regime. And the chamber has heard their testimonies and the testimonies of witnesses and expert witnesses, and that would confirm that those acts actually occurred during the Khmer Rouge regime and lifts the veil as to who were behind those acts and who are responsible for those acts. Thank you.
Yes, good afternoon. I'm Christine Martineau, one of the lawyers for a civil party group that belongs to Avocats Sans Frontières France, and I was pleading on behalf of all the civil parties along with Elisabeth Simoneau-Faure. And I just wanted to make one extra point here. The civil parties didn't waste any time in this trial, because a little bit earlier the prosecutors were talking about the length of the trial. And very often the civil parties, because we are in a civil law trial and not a common law trial, which appears usually to be the standard in international law, but here it's slightly different. And I believe that the civil parties did not waste any time in this trial, and as my learned colleague said, they brought some very, very significant prosecution evidence to bear on the case, and they were allowed to speak, and that was very important, even if we're talking about 35, 38 years after the facts. There were 32 civil parties who spoke here, but they were very much bearing the burden for many of the others as well, and I think that was very important.
Now the floor is open for questions.
Panaya from the Phnom Penh Post. I just wanted to ask for your reaction to the accused statements, particularly Nuon Chea and what he said about the guilt of Vietnam.
Very quickly, but I would like as well to give the floor to my colleague Lima Nine, because she is the one who did respond to Nuon Chea. I do point out that Nuon Chea is very careful to talk about before 75 and after 79, but he absolutely refuses to deal with the evidence that was submitted on the subject of 75 to 79. I wanted to make that point, but now can I give the floor to Lima Nine, please?
Yes, my name is Lima Nguyen. I just would like to say that, you know, in these sorts of settings, when we're dealing with individual criminal responsibility, it is always an interesting thing to attach a human face behind perpetrators of mass crimes. Now, when we listened to Nuon Chea and Khieu Samphan and heard their versions of the story, it's still very difficult to reconcile the masses of evidence that was raised during those 212 days of trial to their statements about not knowing what was going on or not being able to foresee the massive and tragic consequences that passed from their policy decisions. Now, in relation to what Nguyen Chia says about Vietnam, I think the point of these criminal proceedings is to try for individual criminal responsibility. Of course, there is a context to everything, but at the end of the day, what we are looking at is responsibility for conduct that resulted in massive, tragic, devastating and lasting harm to a massive scale of victims. So, you know, in light of what happened before, what happened after, let's look at what happened during the time and look at their conduct, because that is what actually attracts the criminal liability. As I said in my closing remarks, blame on, you know, Vietnam, United States, Thailand. It's clear that Nguyen Chia places the blame on everybody, but does not address his own conduct.
I wonder if you could address, please. I'm Kate Derniker from the Cambodian Tribal Monitor for the International Center for Human Rights in Chicago. Can you address the wider value of being geographically synchronous with your the people that were in the civil party group, as opposed to some of the other international tribunals who have had to work at a greater distance from those who were affected by the crimes?
As for the victims of the crimes that took place during the period of 3 years, 8 months, and 20 days, there are a lot of victims of those crimes. However, for this first segment of the trial, that is 002/01, there are 3,867 civil parties, and they are related to the overall case 002. And as for the first segment, that is 002/01, there are about 1,000 of them who are related closely to the facts within this first segment. They were victims of all kinds of crimes committed during the regime, and they are pregnant. Some of them are pregnant women. They had to walk a long distance during the evacuation, for instance. Before they reach their destination. And at their destination, then they were forced to work hard. And they are the kinds of the victims that fit into the first segment of the trial. I am not sure if I respond properly to your question.
One other point about the proximity. I think it was very important for the civil parties to be able to attend the hearings and see the accused face to face, to hear them speaking when they asked them questions. And it was interesting to see that the accused accepted to speak when the civil parties were putting questions to them. So that proximity was, I think, something that was extremely positive in this trial. Just one more point, Christine Martineau. For the civil party lawyers that have clients, it's very important to see them in their context, in their country, in different meetings and forums, to meet them through interpreters and so on. That's very important as well. I think that in the future, international trials which have been moved right out of the country and the absence of civil parties can be dealt with. The kind of presence can be modified, if you like, but I think it's terribly important that these people be present one way or another.
More question?
Any more question? We have 5 more minutes.
Question or no question? If no question, we close.
So if there is no further question, maybe the lead co-lawyers or the lawyers for civil party may make further comments. Hong Kong soon. I'd like to add a little bit. Although there is a trial in this first segment, that is 002/01, and that it has concluded today, what the victims want is for the trial chamber to find justice for them concerning the charges against the accused. The accused have been charged for various crimes, including the war crime, genocide, and serious violations of the Geneva Convention, etc. So the victims want to see the accused prosecuted for those crimes. In particular, some of our female civil parties, they want the accused to be prosecuted for the sexual violence and the sexual rape that took place during the regime, as well as the elimination of a cultural wedding and the killing of targeted groups. Through this trial, the trial chamber actually allowed for some presentation regarding the killing of a targeted group, including the Cham and the Vietnamese. And we want the trial to be conducted for the prosecution of the acts committed on the killing of the target group, including the 17 April people group and the Lunar officials. Because for the Khmer Rouge, whoever that was regarded as enemy must be smashed, as indicated in the minutes meeting on the decision to smash inside and outside the party's rank. And in fact, the policy of the Khmer Rouge was established since 1973, as Duch said. And in fact, the movement started from 1971 when prison in Leang was established and Lunar soldiers were detained and later executed. So it was indifferent comparing those events that happened there and during the regime. What happened between 17 April 1975 to the 6th of January 1979? There are some surviving documents. Although the documents bear no signature or the stamp, they did know what happened there. Moderator, maybe the floor can be given to another council and then followed up by the lead co-lawyers for the civil parties.
Thank you. I think firstly it needs to be said that the civil parties' participation mechanism in this tribunal is an unprecedented process. My colleagues have mentioned earlier 8,000 civil party complainants and witness applications altogether, 4,000 civil parties. That's a massive number of participants in a process such as this. I think that the importance is for these types of mass historical crimes is that the victims and the civil parties contribute a great deal to the prosecution case and to the evidence that's been raised. As a civil party lawyer working very closely, directly with the clients I represent, we hear their stories. We hear from them, from their own memory, the evidence. And in a process like this, it's really important to capture that because, it's a long process and every day witnesses are dying, same as the defendants. So I guess what I have to say is in a mass criminal proceeding such as this, much of the evidence of what happened on the ground come from the victims themselves, and it comes from their memories of what happened to them all those years ago. I hope that somewhat answers to the question of the perspective that we get working in close proximity with the clients.
Thank you. And Ms. Elizabeth Simino-Ford, and then it will be concluded by Pek-Ong. You may proceed.
On the future trials, this is perhaps the least positive part of our press conference. Ideally speaking, on the civil party side, we hope that the next trial will be held. Now, there is a reality which is worrying us all, and you're aware of it, and we can't pretend it doesn't exist. We are aware that the circumstances are difficult, and that's why, once again, I want to stress that this first trial has been something extremely positive, and itself will have brought a great deal to all of the civil parties in case number 2, because they have all participated one way or another in this first trial. I would prefer us to say clearly that this first trial has been extremely positive, rather than saying it stands for nothing without any future trials, because that, in my view, is just not accurate.
Victims as well as the general public have raised the questions and asked themselves or ask the lawyers when they meet them. The question is why the trial at the Khmer Rouge Tribunal takes so long. And the money that has spent at this tribunal is tremendous to them. And what I can respond to that is justice is invaluable. And if there is no way to search for justice now, then we would not have any further opportunity to do so, as the accused may die, and there will be no further tribunal to do so and to prosecute the accused. And what we are doing is to strictly and properly following the procedure. And if we need to find justice, then of course we need to spend money to do so properly, in a proper way. And if you look at other international tribunals, they have spent much more than what has been spent here at this tribunal. So we need not to lose our focus, and what we are here today is to find justice for the victims and to have the participation of the civil parties and the victims in the proceeding, and that the facts belonging to them can be shown publicly through the proceedings in this court. And for that reason, this will greatly help them to deal with their emotion, and that in the end they will be able to the remedy of a reparation. And for the future trial of 002/02, I hope it can be done completely, and that the entire case 002 can also be done completely. And finally, I'd like to appeal to donor countries and other individuals or institutions to finance this court, so that justice can be found for the victims and the civil parties. Thank you. And I'd like to thank the civil party lawyers for their participation in this press conference at the conclusion of the closing statement. And the time is now up. And once again, I'd like to thank the lawyers for the civil parties, as well as the national and international colleagues from the press or news agencies who are here to attend the press conference. And I'd like to thank all other colleagues who assist in this press conference. And I'm sure I will meet you at some point in the near future, and I'd like to declare the closure of this press conference. Thank you.